So, Nayan Kumar, can you please introduce yourself?
Indeed. My name is Nayan Singh. I've done my high school and intermediate from St. Joseph's College, Prayagraj. I've completed my graduation from Chanakya National Law University, Patna, and my post-graduation from Vanessa Law College, Indore.
Okay. So you're from Prayagraj, right?
Actually, I'm a native of Bihar, from a small village, Narpatnagar in the Madhubani district. But because my father was in a transferable job, I was raised in Allahabad.
Okay.
Currently, my address of correspondence is in Bhopal.
Okay. ठीक है. So why Bihar? Why Bihar Judicial Services?
Bihar was not something by choice. I considered destiny because I never had a plan to go for judiciary at the first place.
Okay.
I was preparing for civil services.
Okay.
However, things were not working out. Then the notification of Bihar judiciary came, and incidentally, a lot of the syllabus overlapped with UPSC. For example, the GK portion, then the lack of procedure in pre and mains as the weightage is concerned. So,
Lack of procedure as in?
procedure law, as in
Okay.
if the pattern is seen in pre, hardly 10-15 marks procedure is asked. And
So
then
that means procedural law पे आपका कमांड उतना नहीं है because अभी आपने बोला कि procedural law कम होने की वजह से आप you were able to clear. But as far as we know, after becoming a judicial officer, procedural law is something जो कि आपको you have to be very well versed with it. So don't you think अभी जो आपने बोला उससे it gives us one reason not to select you?
indeed not, ma'am. I would humbly like to disagree. As I said, I was preparing for something different. And at that juncture, the demand of the examination was not based on procedural laws. However, I understood that it is important because at the end of the day, one of the papers had procedure law. So I studied, I worked hard, I tried to understand the concepts to the best of my ability.
Okay.
And right now, I can say that it is not my weakest one. It's not my Achilles heel. Yes, it's not my favorite subject, but I have the decent proficiency. And with hard work, I understand whatever demand the profession puts forth, I am going to embrace it as a challenge. I am going to work hard. And this is about learning. It's a process. I am going to put forth the best foot forward. And whatever my current corpus of knowledge is, I am going to better it. And I'm pretty confident based on my own journey that I am going to exceed whatever expectations there are. And
But what you just said is Bihar just happened to you.
indeed,
So what I was looking like I always look for is there has to be a dedication.
indeed,
Because अभी आपने बोला कि मैम वो हो गया because of overlapping syllabus, वो हो गया. And that's what I can infer from your answer is you were not dedicated. You were never dedicated towards judicial services because you just took it as an alternative option, right? So, do you think that is sufficient for a judicial officer? Because being a judicial officer is not just a job, rather, it is a responsibility and it is a contribution which you are making towards the society. So, can you justify your dedication? Because you're from your answers, I don't see it.
ma'am. I genuinely feel that the competition is so tough and cutthroat that if I was not good enough in procedural laws and if I was not dedicated for the services, I would not even have made it through past the prelims. I have done that. I have passed the mains examination as well. So, yes, it was not the first choice. I concur completely. But that does not mean that I did not have the dedication. Once I took it upon myself that let me just give it, and I am that sort of a person. If I am attempting something, it's not half-hearted. It is full commitment. Just because it was not my first career option does not mean that I did not put forth the best foot forward. My commitment was there, and I think it is something that the result speaks for itself. So I would humbly disagree on this point that I did not have the commitment required.
So, have you exhausted all your attempts of civil services?
Indeed not, ma'am. Indeed
Then,
not.
are you planning to appear for UPSC again?
Right now, I do not have any such plans. I am just focusing on the current journey, and depending upon whatever result I gain, uh, whatever career options are available, I will analyze, because at the end of the day, age, then the financial stability and everything comes into place. Whatever would be the best for my own personal interest and for the familial interest, my family's interest, I would take that into consideration and then decide as to which career option would be best suitable at that point of time.
सो हम यही कंक्लूड करें कि आज अगर हम आपको सिलेक्ट नहीं करते तो हम दोबारा आपको पैनल के सामने नहीं देखेंगे क्योंकि आप उसके बाद यू विल स्विच अगेन टू यूपीएससी.
Indeed not, ma'am. Indeed not, ma'am. Because I consider it, if you do not select me, I would not take it as a loss. I would introspect and then again come again, because I've already worked hard for it. I know I have what it takes to clear the mains. I will do it again, and this time, hopefully next time, if given an opportunity, I will try to be better version of myself.
Okay. Give me three reasons why we should select you as a judicial officer today.
Ma'am, my first reason would be empathy. I think I am a person who imbibes empathy, and in this job, in this profession, empathy plays a very important role. We understand whether, with reference to civil courts under 151, with reference to the High Court under CRPC under Section 482, or the Supreme Court under Article 142. Whatever laws, where laws fail to deliver justice, the courts have been empowered to exercise their rights to dispense complete justice, and that cannot happen without empathy. Whether it be the PIL, whether it be other tools to dispense justice, empathy plays a very important role. So I feel empathy is there, is a prime virtue. Second is my moral and ethical compass. I understand that there are some virtues which are commanded by this profession, like integrity, non impartialness, and others. So I believe having that in me, I will be able to discharge whatever is expected of me and in fact do better.
Are you impartial?
Indeed, ma'am, I consider myself impartial.
Can you justify this?
Indeed, ma'am, like from a life experience itself, I was given a leadership position in my university days. I was the convener of the academic and debating committee. At times there were situations where I was in a dilemma whether to choose my friends or favor a junior or just be neutral. I took the punt. I was of the opinion that if my relationships are dependent on my action of neutrality, they are not harvested properly then. So I decided to stick with the rule, the command, what it commanded, because if I select someone for a certain thing out of partiality, out of bias, that means a person who was deserving has been left out. And that is something that my conscience would just bigger me constantly. So I consider myself accountable to my conscience and decide as per it.
Syllabus was the only reason to choose Bihar Judiciary?
No, ma'am. There were other considerations as well. In
Like?
fact, there are five major considerations why I opted for judicial services. Number one, the first three are the three P's of my decision: power, prestige, and purse. Power, because I feel that in a society where you have gained education, you should become a tool of change, an instrument of change.
So
And I
that means अगर आप पावर से ही इतना ज्यादा fascinated है, so where there is power, there is misuse of power also.
Indeed, ma'am. This is why I said that the moral compass and the ethical uprightness of a candidate is a must in this profession. If power is given and it is properly utilized, we can see a world of change around us. But if it is misused, then we can say the world getting destroyed. So power is a postulate that really excited me, because I do not feel that with the current crop of knowledge that I have, that I should be outside the system and hoping to bring change. Why? being in the system, I'll be in a better manner. I'll be facilitating change. The second was prestige. I come from a humble middle class background, and for us, judiciary holds a huge reverence in the society. People look up to it. The trust factor that is with this profession is something that is uncomparable. So to be a part of the workforce attached to the judicial services would be an honor. Third would be the purse. It pays decently for my services, whereby I'll be able to take care of my own interest and my familial interest, and access resources, accommodate resources, accumulate resources, which would enable me to discharge my functions and grow in a better manner as a person. Other two are fundamental in the current scheme of things. The first is the work-life balance. With whatever has happened in Ernest and Young.
But I think you didn't get my question.
Sorry.
My question was why Bihar Judicial Services?
Why
वो
Bihar?
जो आप मुझे बता रहे हो, this is general.
Indeed.
And ये जो आप मुझे बता रहे हो, this is basically general features of any government job. All right. Purse, prestige, it comes with so many government job positions. But what I wanted to ask is why Bihar Judiciary on the first place? Because I can see you are residing in Bhopal. You could have prepared for Madhya Pradesh Judicial Services. You are from Prayagraj. यू ऑल्सो वहां भी जीके जीएस आता है तो वहां भी आपका सिलेबस काम आ जाएगा जो आपका एक फैक्टर था. Why Bihar?
Indeed. Sorry for digressing from the issue. So, as I said, Bihar it came as an option. And the fact that I am a native of Bihar, there was some connection. There was some connection to the homeland, and I consider it my destiny. It is not that I did not try in other judicial services. The moment I was preparing for MP, they came up with a notification that you should have scored 70% or higher,
Okay.
or have a 3-year practice. So I was not practicing at that point of time, and my percentage was around 66%.
Okay.
So it did not work out then. And UP, I attempted, but I could not get past pre. I understood that my preparation was less. I prepared, and then came Bihar, and then I gave it, and then here.
So are you planning to appear for UP again?
Right now, I do not have any plan. I just saw yesterday that a notification has come. If things work out well, I have no reasons to pursue UP. But if it does not, then I'll weigh my options, and most probably I will be appearing for the UP Judicial Services.
Okay. अभी आपने बात करी मधुबनी की.
Indeed.
So what is it famous for?
It is famous for primarily two things. The first is the Madhubani paintings. There is a legend that it is near Janakpur. Sita Ma was born in Janakpur, and this was the moment where Raja Janak asked the painters to create a new form of painting, and this is how Madhubani painting came about. It has themes of Ramayana, other distinct themes related to religion, and very beautiful motifs and prominent colors, and even the eye features and the features of faces are very beautiful. It has the geographical indication in India and is very prominent. The second is the Maithili language. This entire region is called Mithilanchal. That is a region where Maithili is spoken, and it is the only language that is spoken in there are three main languages that are spoken in Bihar: Maghi, Bhojpuri, and Maithili. While Bhojpuri has more commercial traction across India, it is Maithili, because of its rich culture, that has found a place in the scheduled languages and in scheduling. In 2003, I believe, by the 92nd Constitutional Amendment Act, along with Bodo, Santhali, and Dogri, it was inducted and made part of the scheduled languages.
Okay. ठीक है. Over to you, sir.
तो नायन आपके ऑप्शन सब्जेक्ट क्या क्या थे?
So it was constitution and administrative law, Hindu and Muslim law, and contract and torts.
Contract and torts. आपने LLM भी की हुई है?
Indeed.
क्या आपका टॉपिक क्या था उसमें? Dissertation topic?
Dissertation topic. It was a right to be forgotten in the digital era.
Okay, what was the moot issue that you dealt, and what was the outcome of the same?
So the main research question revolved around these students. So the first case in where the Supreme Court categorically dealt with the right to be forgotten was K.S. Swami judgment.
Was
And
that the first case?
where the Supreme Court categorically dealt with the question of right to be forgotten. Here, only one judge, Justice Honorable Justice Krishna Paul, was the only judge who mentioned that right to be forgotten needs to be appreciated in the context of India as well and the virtual setting, and laid down guidelines. But I found that the guidelines were not sufficient enough, and there were contrary judgments from different high courts where it was not properly appreciated. So this was the moot question whether we have a proper jurisprudence laid down to deal with right to be forgotten case. It is only recently that the Supreme Court has decided to consider it and has taken it in one of the cases. It is yet to decide on it. So that was the moot question, and my conclusion was that the corpus of jurisprudence, the Indian jurisprudence, that is, with reference to right to be forgotten, is still in a very nascent age, and whatever guidelines have been laid down are not comprehensive enough to deal with the challenges.
So have you made any suggestions therein?
Indeed, sir, I made the suggestion that there should be a privacy law that was in the pipeline in the BN Sri Krishna committee. However, I said that right to be forgotten should also be accommodated, but this was not accommodated by the committee. It is still not considered a cogent issue to be dealt with, and according to my understanding, that the jurisprudence of European Union under the GDPR has to be appreciated. The practices all across the world has to be seen and and applied accordingly in a nuanced manner in the context of India.
Okay, so how can they be applied? For example, if we look at the right to be forgotten, where in the constitution would you say that this right can fit? Apart from right to life.
Actually, sir, it has not been explicit, like right to privacy, it is not explicitly named down. And it is an offshoot of right to privacy, the right to be left alone. Wherever it is.
Can you define privacy?
Indeed, sir, indeed. I think the Auto Shankar case, the R. Rajgopala case, the Supreme Court understood privacy as the right to be let alone, the right to be left alone from disturbance, and whatever are intimate details or intimate issues, it protects that from the interference of other competitive rights that are right to know under Article 19, right to speech under Article 19.
Okay, so if a person is by their own virtue, by their own choice, they are disclosing some intimate facts or intimate information about them, would you call it, is it under the right of privacy?
Sir,
and after that, can they have the right to be forgotten regarding the same?
it is. Sir, the entire idea of right to be forgotten is based on the adage that every saint had a past and every sinner has a future. If a person, by exuberance of youth or any other reason, has on social media exposed himself or has laid down any details which are not necessary for the general populace or not relevant for that matter, and if he later realizes that it is only harming his interests, then he may seek the recourse from the constitutional courts, and the constitutional courts will then have to balance it against the contrary interest of the society of right to know. If they feel that it is not necessary, they can exempt this act of negligence or innocence of the individual and grant him the relief that he seeks.
Okay, and when you look at the right to privacy in accordance with the Puttaswamy judgment,
So,
if you look at the right to privacy with respect to Puttaswamy judgment, how would you say it is affecting the right to be forgotten? Because as far as I can recall, therein Justice, I believe it was the previous CJI who retired yesterday only, he told that privacy is something which you want to disclose to others, which you don't want to disclose to others. But once, even something which is intimate to yourself, that you want to keep to yourself, that is privacy. But once you disclose it, that is no more privacy. So, in that context, where do you define this right to be forgotten?
So the question, like this issue, I studied this issue that the internet never forgets. Whatever is there, it is there with permanence.
Right.
So if somebody feels that okay, like suppose I am a young person and my mother is a TikToker or a influencer, and she's put up a photo of me, and I feel that I do not need this photo. It is of no utility to the world. I could request the court that it, and I understand that it is a very childish example, but I can request the court to put it down. And if the court feels that yes, it is of no utility, the court would.
So should the state be involved this much in these kind of activities, which so far as you have put this in your own example,
No, this was a
saying
very
it to be childish in the
childish
first
example.
place.
I take the real world example. So there was this lady who had a divorce case, and the case was every time somebody searched her name popped up with reference to the divorce, and because of it, she was having problems getting married. Now, whether she got divorced or not is of no business for the world to know. So the court directed that every time it is put on the search
So
engine.
this fact should have been hidden.
Sorry.
This fact that she was not, she got divorced earlier should have been hidden.
It is seen in the context of every case. Here, it was seen that it is of no business of others and the individual right.
Okay, let's suppose she got married and she did not tell this to her, second husband that she was already married. What will be the recourse available to the husband in this scenario under the Hindu Marriage Act?
Sorry, sir, I'm not really like. May I take a guess?
Sure.
If the consent of the husband is not informed, but again, I do not. It is very difficult to answer.
Will it amount to fraud or not?
Sorry.
Will it amount to fraud? So far as Section 12 of HMA is concerned, will it amount to fraud?
May I take a moment to.
Sure.
Actually, sir, had I been in a position to decide, I would have decided in favor of the wife. I would not have considered it fraud because it is not something where the material interest of the husband gets compromised to a great degree, and the balancing the societal interest, I would have not considered it fraud.
What is Section 12? What does Section 12 provide for the term fraud?
It says that where there is an intentional deception that is done to secure consent.
It says intentional deception.
No, that is the meaning of fraud. I'm just interpreting the provision.
Again, I'm saying in the context of Section 12 of HMA only.
In the context of Section 12 of HMA only. Again, I would not have gone to about this under fraud.
Because Section 12 itself says, and you have Hindu laws as your option subject as well. It says fraud regarding the circumstance or the ceremonies itself or the circumstance of the respondent. They should be taken into consideration, and in those bases, the person can take the marriage to be avoided.
It is. However, I would not have considered it a material interest. For example, if it was a pre-marriage pregnancy, that would have been a consideration. Again, it all depends.
So a previous marriage is not a consideration at all. And if this fact is hidden from the second party, would you not say that it provides them or gives them a chance to even rethink of their decision?
In itself, but again, here the facts are to be seen in has to be clearly weighed down. If we just say that the fact of previous marriage was hidden, but how long was the previous marriage? How is it impacting the mental state of the?
It was
or whether
there was a marriage, right? Previously, she was previously married, and subsequently she got married to another person without telling him that she got divorced earlier, right? So tell me, according to Section 12, would you say it would amount to fraud or not? That's it. That's my question only.
If that is the whole corpus
That is the
of
whole
facts,
crux, yes.
I think that he has a claim, but yeah,
लेकिन आपने बोला था पहले that will not be a material fact.
I think he has a claim, but again, as a judge, I would not have granted him this benefit because I do not think that it is a material interest.
So should it be the material interest of the judge? Should it be the material thinking of the judge or the respondent or the petitioner?
I think it should be based on the public policy and the societal interest that a certain decision with reference to marriage, because it also has societal context. and the precedents will also have a domino effect. So I think in this context, I would have considered the surrounding circumstances and then accordingly taken the decision.